and seek to remain in Parliament under their new political status. If you are an independent MP, then Article 97(1)(h) requires that you vacate your seat if you join a political party in Parliament and you seek to remain in Parliament under your new political status. He didn't end there, and he said, a purposive interpretation of Article 97(1)(g) and (h) of the Constitution confirms that their focus, as in the framers of the Constitution, their focus is on safeguarding the electoral mandate during the current parliamentary term and not on restricting MPs' political activities in the next electoral cycle. Historical examples, contextual interpretation, and the inclusion of Article 97(2) all point to the same conclusion. MPs' current parliamentary affiliation remains intact until they actively change their political allegiance during their term, not when they express future political intentions. Yep.
Samson, good morning to you. Good morning to your distinguished panelists so assembled this morning. Let me say that I agree in its entirety the decision of the majority on this subject matter. You recall that I was on your studio some few weeks to express similar position.
2 weeks ago.
2 weeks ago. That until the MP has physically moved in Parliament to change the character of his political lineage or situation, you cannot say that 97(g) and (h) has been triggered. I made this point here. Because you see, Samson, let's understand this point. Parliament is elected for a term specific. 4 years, 4 years. Not more than that. Since 1993 up to now, so this is the 8th Parliament for a term specific.
They stated that, they stressed it.
Good. Now, everything that happens in Parliament for an MP to change his character must happen necessarily in Parliament. What does it mean to say that the MP has changed his character whilst in Parliament, Samson? The MP came to Parliament as a member of a political party.
Let's take Formina.
Formina came to Parliament Esiama, as an independent member of Parliament, though earlier on he was a member of the New Patriotic Party.
Yeah, and he
won independent.
Yeah.
Now, whilst in Parliament, as we speak, the MP says, in future, the 9th Parliament, I want to contest as a member on a ticket of the New Patriotic Party.
Which he has filed his nomination.
Now, Samson, in Parliament, the sitting arrangement is only two. Either you're on the left or you're on the right majority, minority. There's no middle ground. Now, if you come as an independent member of Parliament, you must decide whether to go and sit with the majority side or the minority side. As we speak, Esiama he came to Parliament on the majority side. Sorry, sitting with the majority side, and he's not sitting with the majority side. And I made a point here that when Esiama moves to the minority side, you cannot say that he has crossed carpet. In the same vein, these two MPP members of Parliament, that is, remember the name, the other one.
Cynthia Morrison.
Cynthia Morrison, and then the other one.
Is he called Kojo?
Kojo Asante, isn't it? Good. Yeah. They came to Parliament in the name of the party. As we speak today, they have not moved their position from the MPP side to the side of the NDC. So how don't you say that they've crossed carpet whilst in Parliament? The NDC member of Parliament, as we speak, still remains with the side in Parliament. So everything that we are talking about here, the Constitution makes it very clear, it means that it must happen in the life of the Parliament in Parliament, not outside Parliament. So when somebody plays a certain meaning, and by the Speaker of Parliament, that to my understanding, the filing of your nomination as independent member of parliament or the thing of a political party amounts to cross-carpeting, that you have left the party that brought you in the parliament, and so therefore, to my understanding,
let's
you have
be
vacated
careful.
your seat.
Let's be careful what the speaker did not say. So let's not project what he did not say.
Oh, you can.
He gave the definitions of what cross-carpeting is.
Yes.
And
something that the record is before you, and I have it here as well. So in case maybe I'm veering off.
If you're referring to a record, be specific about
yes.
it. Mm-hmm.
All I'm saying is that the Speaker of Parliament, Right Honourable Aban Kingsford Sumana Bagbin, placed a certain meaning on Article 97 G and H. And for him, his view was that the mere filing of nomination with the EC amounted to a vacation of the seat of these members of Parliament. That was his understanding. And then the majority side also placed a different meaning. That no, it doesn't apply. Because this is all futuristic, not what? Current. At that stage, something, the issue of interpretation arose. It arose. And so therefore, to my mind,
at which stage did the issue of interpretation arise?
At the stage where the Speaker of Parliament placed rival meanings to the provision of the Constitution. Because his understanding of the provision and that of the other side clearly were at par. They were at par. And so therefore, to my mind, I thought that the Speaker, at the time when the rate was even filed, with an injunction added to it, he would have just stayed his hands. Look, I have made this point very clear.
You just said something, and it's instructive.
Yes.
You said the time when the controversy, so to speak, arose was when the Speaker gave the announcement in Parliament.
He gave a ruling. He says that announcement.
I'm using his words.
Okay.
Okay.
I remember he said that
he actually said he gave information.
Adjourning to give a reasoned decision on the matter.
Now wait, the standing orders of Parliament on which he relied said he's supposed to give information to the House.
Right.
So he gave what he calls information. We know the effect of it.
Yes.
The court simply says that the effect is a ruling. Now, this decision at the very onset says the suit was filed 2 days before that decision.
That is correct.
So do you see that there's a problem in law as about the course of action accruing?
You see, the Supreme Court made it very clear here, and at the very beginning of the decision, that, and you see, I made this point the last time, the Speaker has hastened slowly. Maybe it will be where we are now. The Supreme Court made it very clear. They said that if the issue was just about future happiness, they would not have been able to intervene. And for the fact that the Speaker of Parliament now made a decision, a ruling, which had the effect of entering the Constitution, that's why the adjudication was now what? Invoked. So you see, for me...
So you agree?
Yes.
That at the time that Afenyomakin went to court,
yes,
the course of action had not yet accrued.
Well, I agree with you.
You agree on that?
I agree with you.
Okay.
I agree with you.
In law...
That is why... Hold on.
In law and in your practice, does it happen that a course of action has not accrued and a court will entertain you when you go before them?
Well, but when you file a process in court, you have just filed it. Nothing has happened. What happened in this case was when the orders were given, which had the effect of changing the character in Parliament, that application for stay was brought.
You're moving ahead.
I'm not moving ahead.
Yeah.
I'm not moving ahead. I'm saying that, you see, assuming the Speaker of Parliament, at the time the rate was filed with an injunction attached to it, he said, well, for me, I stay in my hands. I'm not going to move. Well, let the Supreme Court decide. If the Supreme Court decides, then I will now come in and go and be abided by what the Supreme Court says. I'm saying we'll not be where we are now. The point I'm making is very simple. To me, I think that at the time when the court made the stay application, or better still, at the time when the Speaker made the ruling, the plaintiff ought to have taken steps to amend the writ, okay? Amend the writ if you look at the release carefully, you realize that some of the releases were made redundant because of the way they were couched. Amend the rate as for specific reliefs, which will bind the speaker's hands when one way or the other. But by and large, if you read the entire judgment, it is very clear that the court...
So stay there briefly for me. In your practice, in the very normal scheme of things, when you go to court, the standard, we know that there must be predictability. Otherwise, a judicial system doesn't exist. There must be certainty. So, first, if you had a client and somebody approaches your client with a writ together with an application for stay of, an application for injunction.
For injunction, yes.
An application, not that it has been determined. The same way happening in this case. And they are serving it on your client. Let's say they've even served it on your client about something your client has not done yet. What would be your advice to your client?
Yeah, my advice to the client is that, you see, because the injunction application is seeking to tell you that don't do X, please don't proceed to go and do the X, because the substance of the application is saying that please don't proceed. So don't proceed. Because you see, if you proceed, and the very thing that the court is being sought for, to injunct you, you go ahead and go and do it.
Wouldn't you tell your client first? Wouldn't you tell your client first that since you have not done the thing, there's nothing to be injuncted about?
Oh, no. I'd rather
that the person who has brought the suit actually doesn't have a case because you haven't done it.
You see, one thing that I'm very careful about, I'm saying, is to try to be in contempt of court, or try to advise the client in a manner that the client will be in contempt of court. Look, you know orders of court, and you are aware. Even if they are made, whether they are rightful or they are wrongful orders, you are supposed to obey those orders. So my humble view is that once you file a suit and attach injunction to it, and you serve the client, I have to file my hypothesis to respond to it. Let the court decide, one way or the other, how it should go. I would never advise the client that proceed to go and do the very thing that the plaintiff is seeking, that stop, don't do it. No, I would never do that.
Right.
I would never do that, and I've never done that.
So let's go to the substance, back to the substance.
Yes. So, as I was saying, if you look carefully at the 97 1 G and H, which really, you rightly pointed out, that you have to make sure that the person at the time of cross-capping or whatever it is has happened in Parliament. Some have suggested that, should have gone to the High Court. High Court had jurisdiction in the declaration of a vacant seat. I agree. But you see, the plaintiff was not in court to declare a seat vacant. He was in court for interpretation of Article 97 1 G and H. That's the crux of the matter. And I read the minority position on the matter. They were so silent on whether or not an interpretation arose or did not arise. They didn't touch about it. All that they were saying is that, well, the forum was to have been a High Court, so you have go to the High Court. But you see, you're going to the High Court for what? For declaration of a vacant seat or for an interpretation of 97? If it was the interpretation of 97, then obviously the Supreme Court was seized the jurisdiction to interpret the matter as far as the part that placed rival meanings to the provision of the Constitution. It was so clear.
Is 99 really about declaration?
99 1. Today you have helped me with borrowing me with this, your Constitution. Now 99 1. So the High Court shall have jurisdiction to hear and determine any question whether A, and I think let me go to where, yes, a person has been validly elected as a member of Parliament, or the seat of a member has become vacant. That's what the High Court will do.
To determine a question.
A question.
That is a controversy.
Yes.
That is a dispute.
Yes.
Whether a seat has become vacant.
Has become vacant.
You are saying this is not what this suit was about?
No. This was about interpretation of 97. That's why you should distinguish it.
The interpretation was to say that a seat has become vacant or a seat has not become vacant. Is that not it?
The interpretation was the resultant effect of the interpretation of 97 will let you see that by your conduct, by what you have done, you have declared a seat vacant, which you ought not to have done in the first place.
Right. So there's a question.
Are you getting my point?
So there's a question, there's a dispute
Yes.
about whether, in fact, those seats have become vacant. Not correct. Is that not it?
No. What the Speaker did in Parliament
Yes.
was by interpreting 97 G and H, and the effect was to declare a seat what? Vacant.
Correct.
These are two things that happen.
And somebody is not happy.
Yes.
That this situation cannot lead to the seats becoming vacant.
Exactly.
So the question to answer, or the controversy, was whether the seats of these four individuals had become vacant or not.
No. The question to determine was whether interpretation placed by the Speaker on 97 G and H.
I know what you're doing.
No.
Okay.
You see something. We need to let the people understand. The interpretation of what the Speaker has done has led to a resultant figure where now a seat has been declared vacant. So let's go to Abrewa, that is the Supreme Court.
What is the bottom line? What's the bottom line of the end game of the majority decision? What's the end game of the majority decision? If it is any different from what I read to begin with.
The end game, to my understanding, is that the majority have now placed an interpretation to 97, and they made a declaration to that effect.
So the end game is that the four MPs, their seats cannot be vacant by virtue of what they have done.
Yes.
How different is that, the end game here, from 99 saying that if there is a question, there's a controversy, or there's a contest about whether a seat has become vacant, the place to go is the High Court.
You see something. Let's understand this way. The Speaker of Parliament did an interpretation. What he calls applying the Constitution was an interpretation. It's his understanding.
And everybody is entitled to do so.
No.
Once they apply the Constitution, you are entitled.
If you are applying it, then yes, you can apply the Constitution.
You interpret before you apply.
You see, but when you say it is clear, how did you write that it is clear? You see, the Speaker of Parliament placed a meaning on 97. He interpreted the meaning of 97, which is the exclusive president of the Supreme Court.
When there is
rival meanings being placed on the provision.
Correct. That does not mean the government institutions and all of us, we don't interpret this Constitution and apply it every day. That we are not entitled. If we have any issue, if we want to use the Constitution, we should go to Supreme Court before we use it. That's not what you are saying. Just education for the public.
Yes, you know, unless there's a controversy on a matter, the courts, you don't go to the court.
Right.
If, for instance, I take a provision of the Constitution or any act of Parliament and you apply it, and there's no controversy, you go on. You are free to go on. But when there's a controversy, the parties to the issue are fighting over the matter.
All right.
And placing rival meanings to a provision in the Constitution or a statute or an act of Parliament. You cannot sit there and say, look, we want to proceed and do it. So for me...
So it doesn't matter that you go to court even before that happens. You go to the court and say, the Speaker is saying something different. And I am also saying something different about this provision.
Yes.
And you go 2 days before the Speaker says that.
You see,
it doesn't matter.
There are different ways of going to the court. And let me put this way. If a provision in the Constitution is not clear, it's unambiguous, you can go to the Supreme Court. And that's 130. For interpretation and enforcement.
You know, if it is, not if it is not.
No, if it is ambiguous.
Correct. You said unambiguous. That's why I was seeking to correct you.
Sorry. If it is ambiguous, it admits double meaning. And the parties are putting rival meanings to it. You can go to the Supreme Court.
Right.
At that one, you realize that it is not about you are going there because people are fighting.
Okay.
Because parties themselves disagree with the
Why did you say a while ago that the plaintiff, Afenyo Marking, should have amended his rate after the development actually happened?
Yeah, because you see, if you look at the reliefs that was being sought, specifically reliefs 2, 3. I may even add 4, but 4 is just the usual this thing. But especially 2 and 3, you see that these matters were overtaken by events. The fact that you want injunction against the speaker from not putting any interpretation on 97, he has already done it. He's done it already. So it has been rendered superfluous, rendered odious here. And then the fact that there should be an injunction barring the speaker from enforcing 97, 1G and H, already he's done it. So, tactically and procedurally, this rate ought to have been amended to get specific reliefs.
What's the effect of not amending it?
That is why the Supreme Court could not give you the consequential orders. That is why. Because the court cannot grant you what you have not asked for. You see, you go to court either as a plaintiff with a writ and your reliefs all listed in there, a defendant with a counterclaim. If there's no counterclaim, you can't say that the court should grant you counterclaim. All right? The counterclaim is a fresh writ or a claim.
All right.
So, if you go to court and at the end of the day, the court says that you are proving your case. So, all the relief that you are asking for, I've granted you some. Or, the relief you are asking for, I will not grant it. But what you have not asked for, the court cannot grant you.
Do you share the views that this judgment practically is empty?
It is not
Kwame
empty.
Akufu,
It is not empty.
Kwame Akufu, Kweku Ansah-Sare,
It is not empty.
Tadiosore,
It is not
among others, say that
I disagree with them.
this judgment does not have teeth.
You see,
It has no grip because there are no orders.
Samson, I made a point just a while ago.
I want you to do this quick so I'll go to the other
Just a
panel.
while ago, whilst the court could not have given orders or could not have made orders that were not asked for. Okay? If you read the judgment in its entirety, you will realize that the Supreme Court, implicitly in the judgment, has said that the interpretation the speaker put on 97G and H was wrongful.
That's plain.
What's wrongful?
That's plain, yeah.
If something is wrongful, what do? The thing is wrongful. What you said it is, it doesn't mean that it is. So that these 4 MPs can just walk to Parliament when the Parliament is recalled and go and take their seats. You can't stop them from entering Parliament. So how do they, the judgment is implicitly in the judgment, it is clear.
Is the Speaker supposed to do something since there's no order against him? Is Parliament supposed to do something since there's no order against him?
You should recall Parliament and let the MPs enter Parliament. They come and do their work. That is all.
Okay.
You should recall Parliament. These MPs can't be stopped from entering Parliament.
The final point on this. I've been trying to illustrate to people who don't have an appreciation of the law, who don't have a training of the law. And I say, when you file a writ, for example, and you say that somebody has trespassed on your land, and you ask the court to declare that that person is a trespasser, they'll declare so, right?
Yes.
If you don't ask the court to make an order for that person to vacate the land and give you vacant possession.
Recover possession.
Yes, to recover possession.
Yes.
What effect
the court you cannot recover possession. You can't recover possession. Once the court they don't make a decree for the recovery possession, you can't recover possession.
So you know that in Accra and elsewhere, there are many people who have gotten land litigation victories. They got a declaration that, yeah, this land is yours. They didn't get any more. The persons they won the case against are still on the land.
Yes, I agree with you. If the court does not decree for recovery of possession, or you don't plead it in your relief, the court cannot grant you. I've had a situation whereby a case I was doing, the lawyer had judgment, and then there was no relief as to recovery of possession. And after the judgment was delivered, they now try to do the enforcement by now entering recovery of possession. I want to set aside the process. And the court agreed with me, because once you don't ask for recovery of possession, you cannot get a decree for recovery of possession. But this particular instance, it's a different thing altogether. It's a constitutional interpretation the Supreme Court did. The Supreme Court, that's why you see the Supreme Court, look at the relief. The Supreme Court essentially granted relief 1,
A, B, and C.
yes,
So, yeah.
Yes, which was declaratory nature, which they came, they were asking for, and the court granted the relief for them.
Thank you. Let me go to